judgment. Please focus. Seal number 3.
What is this?
Oh,
that's a matter. They are removed?
Yes, they are removed.
Yes.
Yes. So that was the first thing.
Yes.
Yes.
Please come. This court by order dated 12/12/2024 has dismissed the revision. While dismissing the revision, this court has observed that in spite of giving a reasonable time to the petitioner to remove the encroachment,
Remove the blockage of pathway.
remove the blockage as per the judgment and decree
Yes.
passed with the court. As they failed to do so, the revision is dismissed. Now the matter is placed before it has come up before this court, and the caption first be spoken to. It is submitted by both the parties that, as per the judgment and decree, the blockage, the obstruction is removed by the petitioner. Concerning the same, the order dated 12/12/2024 is modified, and the writ petition CRP is allowed by setting aside the order dated signs.
They are in judicial custody.
Will give it.
Yes, when they give this order, the court will release them. So,
That's what.
yes, yes. Because I have again, my lords, I approached the trial court for releasing my lords again. So, the court has to pass order on this application, then issue release warrant. That is it.
Give that. Give the file. We set aside, and no, that is exactly in a CRP. That's the order we passed. We set aside that order by further directions.
No question. If they produce
The moment you take this order, automatically, like the order court will pass orders.
Court will release the issue, release order.
Yes. Next.
Announcement. Seal number 4.
What is this?
This one. The other day, in chambers were completed one party.
This is the matter.
That means allowed matter. I am filing wakalat for Yes, ma'am.
Where is that IA now?
Yes, notification.
For Impleading, IA number 2 of 2024 is filed, stating that earlier they completed all the LRs of the respondent number 1. However, the daughter was not impleaded. As such, they have come up with this IA. Then counsel appearing for the respondent submits that he has already filed wakalat.
No,
He has instructions. He has instructions to file wakalat even on behalf of the proposed respondent. 1G. Accordingly, I number 2 of 24 is allowed, and so is impleaded as respondent number I 1G, and the petitioner shall take steps to amend the cost item. Next, where is that? We'll have tomorrow. Let that amendment be carried out today.
First we'll do it.
If you can do it tomorrow, we'll have. The petitioner shall carry out the amendment with the cost title. This is matter tomorrow. Can you file it in the section also? Yes, next.
Seal number 5.
Yes. Or report of the.
I saw the copy. Now I have received a copy. I will go through it and I will.
What it says?
According to them, there is a violation by me. But whereas it runs contrary to their own report which is produced at connection came up, which was conducted by the very same office, same officer.
Please come up with whatever you want, because we have done all this exercise basing on your submission. Then we'll pass appropriate order. This matter on Friday.
I seek some time. I have to get information and I have to ascertain and they have submitted a report which is contrary to their own statement that is an extra K. So I need some breathing time.
As per the order passed by this court, the respondent have filed the report stating that there are violations. Earlier, before directing the respondents to do this exercise,
At the
this
time
court
of-
has passed a specific order if directing the petitioner to file an affidavit. An affidavit is filed stating that there is no violation from the there is no violation. And this court has also observed that if the report shows that there is any violation, appropriate orders will be passed against the petitioner. Now, the counsel appearing for the petitioner submits that he'll come up with his objections to the said report filed by the respondents. List this matter on 8th of January. Yes, next.
Seal number 6. Saurabh Hegde.
My lord, I represent the revision petitioner, my lord.
Interim order order granted is extended till then. Yes.
My lord, I had taken paper publication, my lord. In fact, there are two matters. In one matter, my lord, on the earlier date of occasion, that IA was not put up.
So
However,
no. You have taken in which paper, which matter?
my lord, in both the matters I had taken because in one matter the order was passed connecting both the matters. So I have taken in both the matters. That was kindly see the previous order, my lord.
Oh, by order dated. Dated 2011-2024 had permitted the petitioner to take out the paper publication in Vijayavani, Kannada daily newspaper in both the petitions. Accordingly, the petitioner has taken out notice and placed the same before this court. Considering the same, the notice to respondents is held sufficient. This is
My lord, one more submission, my lord. That IA doesn't survive for consideration in the next matter.
The notice to respondents self-sufficient. In view of the order passed by this court dated just now given the date, dated so in this IA number 1/2024 filed in HRRP number 10005 of 2022. No further orders requires to be passed. Accordingly, IA 1 is closed.
Please, please.
This is matter after vacation.
My lord, kindly interim order may kindly be extended.
On 22nd January, interim order earlier granted is extended till then. Next.
Seal number 7.
7, my lord. That day I have to.
You're saying that the judgment. Okay. What is the judgment?
Your lordship may send page number.
No. What is this judgment?
Regarding whether 9/13 is made an application. If it is dismissed.
It is like this. When you are set ex parte, questioning the ex parte order, you have two options.
Yes, sure.
Either to file an application under order 9/13 or questioning it by filing a first appeal.
First appeal.
That is a regular
Yes.
appeal.
Suppose Supreme Court has held that appeal has been filed and if it is dismissed, then question of filing in 9/13 would not happen. But if the 9/13 has been filed and if it is dismissed, then appeal can also be maintained. Appeal is maintained. That's what para 8.
Please read.
Yes. This court held that though the dismissal of the appeal under section 96 of the against ex parte application under rule 9 FPC will not maintainable. There is no bar for an unsuccessful defendant adopting both remedies simultaneously. In a such case, if a regular appeal against a decree is dismissed, obviously the application under 9 Rule 13 of 9 of CPC cannot be pursued. The reason is that explanation under Rule 13 of Rule 9 of CPC lays down that there has been an appeal against a decree passed ex parte and appeal has been disposed of on any ground that other than the withdrawal, application for setting aside ex parte decree will not apply. However, in the event an application under Rule 30 of 9, Order 9 of CPC is dismissed, the defendant can prosecute the appeal against the decree as a right to prepare an appeal under Section 96 cannot be taken away in absence of express provision to the contrary CPC. This is the law very now.
Read further.
In paragraph 38 of the aforesaid decision, this court held that when application under 9 to 13 of CPC filed by the defendant is dismissed, defendant cannot be permitted to raise a contention as regards the correctness or otherwise of the order posting suit for ex parte hearing and for existence of the sufficient cause for non-appearance of the defendant. In this case, the question is, when the defendant did not avail the remedy under Rule 13 of 9 of CPC, whether it is open for him to educate in the regular appeal against the decree that the trial court had no jurisdiction for proceeding ex parte against the appellant. In a such case, though appellant would not be entitled to lead evidence in appeal for making out a sufficient cause for his subpoena before the trial court, he can always argue on the basis of the record of the suit that either the suit summons was not served upon him, or even otherwise also, the trial court was not justified in proceeding ex parte against him. The reason is that under Section 105 of CPC, when a decree is appealed from, any error, defect, or irregularity in any order affecting the decision of the case can be set forth on a ground of objection in the memorandum of appeal. Thus, in the case, the appellant can always urge in an appeal against the decree that an interim or interlocutory order passed during the pendency of the suit affecting the decision of the case was illegal. Therefore, from the record of the trial court that order passed to proceed with the suit ex parte against him was illegal, as held in the case of Master. Only when the application made by the defendant under Section 9 to 30 is dismissed, that such a defendant cannot educate in the appeal against ex parte decree that the order directing that the suit was proceed ex parte was illegal or invalid. However, in this case, the appellant has not filed an application 9 to 30 of CPC. Therefore, such a contention can be raised by him. Now, coming to the facts of the case, we find that there is nothing on record to show that.
Now, please come to the order impugn.
Tara?
Order impugn.
Yes. But in fact, the application for 9 to 13 was made in this case. So, Malad, it was dismissed. Against which Malad, the miscellaneous appeal was filed.
Now, let's see.
Then Malad, it was withdrawn with the liberty to Malad approach Malad the appellate court. So, Malad, afterwards, appeal has been filed. So, Malad, it always Malad, it is required open to Malad him.
No, let us see what is that you have done. No, in a regular appeal, what is it? What is that? Is it a judgment and decree?
This is Malad, wherein Malad it was dismissed by the trial court. On IA number 5, under Malad, the 7 to 11 application was made. Malad, what happened? In an appeal, they filed an application under 7 to 11, saying that appeal itself is not material. So, Malad, the question is.
So, what is then even on that also? Two
Two
aspects. No, even after filing an application under Order 9 to 13,
yes,
still you maintain an appeal. That's what is a judgment. You preferred an appeal.
But
you preferred an appeal. Yes. Some order is passed. It's a judgment under decree of the court. Against that, how a revision lies?
No, Malad, what they have filed, an application under 7 to 11.
Ultimately, it is a judgment and a decree of the appellate court, isn't it? It's not an interlocutory application.
Malad, it is amounts to a.
Order 7, Rule 11 is an IA, but still you have to prefer a regular appeal against that.
Malad, what I am saying, by entertaining an application under 7 Rule 11, Malad, which is only applicable in a case of original proceedings.
That you cannot question in a revision, it's the opinion of the court.
No, that's what I am saying.
Right? Whether it is legality or otherwise.
I will put it in this way. Right. If the court which is required to exercise jurisdiction refused to exercise jurisdiction, where the remedy lies. 115 clearly says, if the court refuses to exercise its jurisdiction, and it is amounts to a case decided, and if it is amounts to a case decided, 115 malad is maintainable.
Why not further appeal?
Further appeal, malad, in fact, no, your lordship attends further appeal.
Further appeal only lies.
No, malad, in fact, against which malad there is a specific 7 to 11 malad, there should be there should be a specific remedy of filing an appeal. If appeal is provided, then malad revision may not lie. That is malad fact. But the court,
No, just whatever is the reason,
malad, court
it amounts
on merits.
It amounts to dismissing your appeal. Either it's not on merits, but
No.
on the maintainability.
No.
On the
Yes,
maintainability. So
then, malad, it amounts to refusal to exercise the jurisdiction by the court. That's what I am saying.
why can't you file a regular appeal, regular second appeal against this order? Tell the court why not. It's a judgment under degree. Because where it comes, again it has to come before this court. RSU, which court is this RA?
This is RA.
Is additional district judge. Then it comes to the high court only. So why can't you do that?
I am permitted convert.
Please come. The office has raised an objection with regard to the maintainability of the appeal, maintainability of this revision, as the appeal is filed against the orders passed in RA number 27 of 2022, dated 3rd December 2022. The office objection with regard to the maintainability is sustained, and the petitioner is at liberty to file an appropriate application is at liberty to file the appropriate to avail the appropriate remedy. This is directed to.
What I am saying that this revision itself may be permitted to
convert. And the petition is at liberty
to convert
this revision and file an appropriate petition. History is directed to return the appropriate remedy. Yes.
What I am saying that this revision itself can be converted as.
That's what I said.
Appropriate remedy, we have to take back and. No, what I am saying.
Whatever it is, whatever you want,
if
the he is permitted to convert this revision to a regular second appeal. You want the court to say that also?
Yes.
Regular second appeal.
Otherwise, they will not allow.
Yes. Next. Within a period of 15 days, by January 15th. By January 15th, you should do it. Yes. For statistical purposes. Revision is discussed. Disposed of. Yes. Next.
Seal number 8.
Yes, Your Lordship, one submission. This is a husband's maintenance petition.
Why did you move a petition for this? Please tell the court.
Please, Your Lordship. Since Your Lordship, last 3 times I am taking the notice to the respondent number 2 for the same address which they have given in the execution petition. One or the other reason, Your Lordship.
Signature name differs. Duration.
Last 2 times, Your Lordship, it returned saying that they have received the post but not signed.
What is that?
Signature कन्नड़ में लिखा गया है कि वीरेश respondent name अलग.
Lingamma. So what is to be done now? What is urgency now?
This is an expiry order, Your Lordship, by the vide. She is alleged to be second wife. And respondent number 3 is a minor children. For him, Your Lordship, educational expenses has been awarded by the trial court. He is not even going to the studies. And respondent number 2 is a major, Your Lordship. Now, respondent number 1 is alleged to be second wife. And this is the expiry order. At page number 13, Your Lordship, the trial court order.
Who is R2?
R2 is a first son, Your Lordship, who is a major. And however, in the trial court, Your Lordship, maintenance insofar as R2 is dismissed. Now, order is at, Your Lordship, at page number 18.
You appear for who?
I am appearing for respondent number 1 and 3, my lord.
1 and 3 are who?
1 is the wife, the 3 is minor son, my lord.
How much is granted? How much is granted to
8,000
R1?
8,000 per month, my lord.
To both of them?
Yes, my lord. Last time there is a conditional order that they have not complied with the order passed by this honorable court dated 18/4/2023. There is a conditional order.
However, Your Lordship, I agree, Your Lordship, since my name was not shown in the cause list, Earlier advocate who has filed wakalat, his name was shown.
First of all, deposit the amount, then we will.
It may be remanded with a legal
No.
bill, let them recover your
First
lordship.
of all, comply with the
She alleged to be second wife, your lordship.
whatever it is.
No,
There is an
extra
order.
order came to the house.
There is an order of this court. You can't have both. You can't have an interim order and happily enjoy it from 23 and tell the court now that I'll not deposit the amount. The amount as per the interim order shall be deposited by January 6th, or else the petition, the interim order earlier granted, stands vacated without further reference to the court.
Meanwhile, interim order may be extended. Meanwhile,
Interim order will be
deposit.
extended
Please.
till 5th. Yes,
Record.
next.
Seal number 9, petition Karnataka.
Yes,
Modification of interim order, my lord. Modification of interim order.
modification of interim order. What is interim order?
Kindly see interim order, my lord. Page number 2, my lord. Considering the submission of the line turned process for the petitioner operation and execution of all the parts.
On the condition that the petitioner shall continue to pay an amount of rupees 5,000. See, this is what these people are doing. In the order, in the first para, it says 5,000. How it will be 8,000 again? Absolutely no assistance from these two. Yesterday, another case, that other lady. The order dated 21/11/2024 is modified. Then counsel for the, not modified, then counsel for the petition submits that. In the order, it shows that the petitioner shall continue to pay an amount of rupees 5,000 per month. 5,000 every succeeding month, and also directed to deposit the arrears at 5,000 per month, whereas in the order it is shown as 8,000. The council submits that 8,000. This court has perused the order. It appears that there is a typographical mistake. Accordingly, the amount of rupees 8,000 per month as arrears is modified as 5,000, and they show this to the Registrar Judicial, this order. Yes,
Number
next.
10. Enumerate.
Yes.
There is an objection, my lord. This is an application for addendum. I think please allow me to comply to the course of.
Office objection. You will comply today itself.
Yes, sir. And
Then
finally,
counsel,
it is tomorrow.
then counsel for petition is permitted to comply with the office objections. This is matter day after.
Okay.
If the office objections are complied with, this is matter on Friday. Yes, next.
Seal number 11, Vadiraj. Seal number 11, Vadiraj.
No, there are three office objections. The Kochi has been paid matter, and other two objections are matter. I'll comply with one matter.
For petition is permitted to comply with the office objections. If complied, this is matter on Friday.
Okay.
Yes, next.
Seal number 12, Jendra Bhimakanava.
Comply. Same order. Friday.
Okay. Seal number 13, Nagaraj. Naganmoda Impleading.
We'll comply the office objection. Final.
After vacation. Same by 15th of Jan, objection shall be complied with, or else the petition shall stand dismissed without further reference to the court. Next, 14,
14,
await service of notice, list after vacation on 7th of January.
7.
Huh?
14.
14. 14.
There is some order last time, all 12 orders passed.
Huh?
There is some clarification I have.
what becomes service 30,000. Your lordship stated last time that this 50% he has to go on paying and earlier 50,000 he paid. But order has stated that
Salary of the petitioner is rupees 30,000 and odd.
That's
As granted
a-
a sum of rupees 15,000, it is difficult for him to survive.
my lord, here my lord, 20,000 has been awarded by the trial court. 50% of the deposit and
10,000.
10,000. And out of arrears, because
No, please look at it. This is your order. You have taken it. Please look at your notes. What is this? Because when the court grants 15,000, the court will never say that on the condition of 15,000, the order will be passed. Then counsel submits that the trial court has granted an amount of rupees 20,000 as maintenance, 20,000 as maintenance, and this court has directed the petitioner to pay an amount of 10,000 per month for 5th of every succeeding month. But in the order, it is reflected as 15,000. Considering the same, the order dated 20/20/24 is modified, directing the petitioner to pay an amount of rupees 10,000 per month by 5th of every succeeding month, and the arrears of maintenance at rupees 10,000 within a period of 8 weeks from 12/12/2024.
arrears comes to more than
But you can't now bargain. Interim order is granted on that condition. Yes.
right.
No, but unfortunately, in every order, this is happening.
Anyone mind? Ms. Renata?
Incoming application are filed.
Yes.
3924 mala, this is for non-prosecution.
When was it dismissed for non-prosecution?
3924 mala.
3/9/2024.
Due to non-compliance of purpose objection mala. As per direction of your lordship, for comply to office objection.
There is a tie. File number 1 of 2024 is filed. To recall the order dated 3/9/2024. This court on 3/9/2024, coordinate bench of this court of 3/9/2024 has dismissed the petition for not complying with the office objections. This court, release the docket. On 23/11/2024, had permitted the petitioner to comply with the office objections pending consideration of file number 1 of 2024. They submitted that they have complied with the office objections. Office objections. Is there any delay in filing it?
Yes, 47 days delay.
Huh?
47 days delay.
What is the reason for that?
Reason mala,
First of all, in a 2019 writ petition, you don't comply with the office objections. Then you file an IA. When the matter is called, you don't appear before the court.
due to mala, the certified copy was not available at that time mala, due to the COVID impact also in the mala.
No, there can't be lapses at every point of time.
Only 47 days in filing the.
No, that's a delay. Then why were you not represented representing the
I have filed
matter?
the application, separate application for cancellation of delay.
That you must have filed. I am saying this court on the other day has posted this matter after vacation because there is no representation on your behalf.
No, at that time.
And again, you are come, no, you are moved a memo. You have moved a memo.
Please.
Then the court they have brought it to my notice, saying that in spite the court has adjourned the matter after vacation, again it is moved.
Some urgency mala, the matter is going on before the trial.
No, 2019 writ petition. How can you not comply the objections till now? And what are the bona fides on the part of the client
Sorry, mala.
in pursuing the matter? And it is like, this court will pass an order because the office objections will not, are not complied. Now again, then again is filed before the other court, then it will be recalled. This is not the procedure.
Sorry, mala, the major objection was mala,
We'll condone it on cause. The IA number. What is the condone delay petition? Is IA number?
IA2 of 20.
IA2 of 24 is filed to condone the delay of 42 days in filing the petition. No objections are filed with the respondents, considering the reasons stated. Considering the fact that this is a 2019 writ petition, even till now, the objections are not. Now it is complied. The 2019 petition, objections are complied in 2024. In that view of the matter, the delay of 42 days is condoned on the condition that the petition shall pay an amount of rupees 5,000 to the respondent. The 2000 and everything, you can't have a say on 2000 to the respondent within a week by 6th of January. The list is marked after vacation on 7th. Accordingly, the order dated so and so is recalled, and the petition is restored to file. Automatically, if there is an interim order, it will come into operation. Yes, this is matter on 7th of January. Yes, next.
Bill number 60.
For the petitioners, my lord.
Yes.
My lord, see, a bit after vacation, my lord, there is some inconvenience.
After vacation, at the request of the counsel petitioner on
Date
20th of
will be
January.
given, my lord. Public, keep your.
Yes, next.
Bill number 70. We are very much. She will collect.
Last occasion, was taken matter before the nurse in the chamber. So it was understanding that next date of it today, I have to come with some figure. My party nurse, as of now, he is ready for 10 nurse, but otherwise.
I think the other date was 15 in the chambers. Now it has come to be written.
15, it was the proposal by the nurse, both the advocate before the trial.
No. It is from 20. Their client has started at 20.
No,
Then
they have nurse started at 20 to 25, and before the trial court it was not nurse feasible, and thereafter nurse, when the matter was listed further, subsequently nurse, there was proposal by the nurse, both the.
So now what is it? Now he says
These
10
nurse
lakhs.
up to nurse, only lakhs nurse, with all nurse difficulty is ready.
Now how much are the arrears as of now?
Arrears nurse 5 lakhs and all.
5 lakhs is the arrears. The execution recovery proceedings are pending before the
So,
trial.
if 8 lakhs are the arrears, Mr. Counsel,
That's
8 lakhs are the arrears, what is the big settlement your client is doing for 12 lakhs?
Only thing nurse.
Anyway, he has to pay.
I understand. Well, the only thing is nurse, if at all nurse he is able to person, if nurse, you have not nurse suffered the nurse civil prison.
What is his problem? You said if he is an able person, what is the disability he is having?
So disability is nothing. Nurse. He is no nurse taking care with the nurse, the other person, other nurse brother. And on the other hand, nurse, he is also nurse residing along with the nurse brother in the village, taking care of his mother.
So why when he is an able person, why is he not working?
No,
Why
he
he
is
should
not-
stay with the brother?
He is not getting nurse anywhere. As of now, nurse, he is having nurse some license, nurse having the running for nurse pharmacy. That license has been nurse.
Anyway, we can't compel them to accept your
This is
proposal.
my nurse, the submission as of my nurse, the instruction of my.
12 lakhs is not acceptable.
8 lakhs is the arrears, my lord, at least for 10 to 12 years, till he reaches the age of 18. Basic 82 lakh is spent on education and on kid.
How much?
It is the 1 lakh per year, my lords, including the education expenses and all. In this era of localization. Lords, there are properties in his name to overcome maintenance that are already being transferred in the names of uncles. That is the conduct that is being made by the
Last vacation it was.
Is it so? You have any document?
No, that is not last vacation. Lordship has inquired. There is no minute such documents, and he is not minute having any property. No minute his family is having property. That has been made clear by the minute wife only. That is not. But I am not minute saying that it is suitable amount. But the person who is minute giving, he should be minute in a position to minute given such an amount. He is not having minute. Till today, minute the court was not.
What is the age of the boy?
I can. There is no. I
No,
can.
minimum.
No, when
Even if he is
reasonable,
with him,
I can.
even if he is with him, even if you joined in a simple, very like in a school where which he can afford, By the time that boy completes education, how much it would be?
This is all happened, madam, only because, madam,
He got used to going to the civil prison, let him go, what we can do?
This is all, madam, happened only because of, madam, they have not, madam, sought for the assets and liabilities before the trial court. Without, madam, there being any documents to exercise, madam, the term
Have
of
you
art.
filed before this court?
No, madam.
I said, have you
No,
filed
no,
before
no,
this
till
court?
today they have not, they are not, both the persons are not filed.
Both the parties are directed to raise before this court. So there
And
is
even
statement
when
of
that-
assets and liabilities by the next date of hearing. This is matter on 8th of January. Yes.
Similarly,
I'm sorry, madam, I have made it. Madam.
Yes. Yes.
My lord, suppose in the petition, the expert decree, first on the trial court, the petition carried agriculture where,
How much is granted?
my lord, yet, in the 8,000.
Why have you not, why were you ex parte?
No, my lord, the taken notice on the address is not at all decided.
You filed any MC?
My lord,
You filed any?
no, they filed, after that, they filed an MC. Then only we came to know that, this.
What is the address in the MC?
My lord, that in MC proper address they have issued.
Let us see what is the difference of address between MC and this criminal miscellaneous.
Yes, yes.
Let's see
My
that.
lord, in the MC,
No,
in the
criminal
MC
miscellaneous, you're shown as residence of Sai Spring Apartments,
No, please.
Bharat Nagar, Bangalore.
Please.
Then come to the MC, where is that MC?
In MC, my lord, they have given his exact date was.
Please pass on the copy.
Please.
Take that. Same address.
No, in MC, they have given the local address where we are residing. In criminal miscellaneous, they have given the Bangalore address. My lord, the address,
Criminal miscellaneous is before this court.
please, my lord, no, not at all, the MC.
Criminal miscellaneous. This is the
Yes, we are
MC.
challenging the criminal is expert decree, my lord.
Correct.
In MC, recently they have filed it.
This is MC, is it not? What have you given to me? IMC, same address, both are same.
In MC, they are local. No, MC, they have given proper address. In CMS, they have not given.
No, let me please read it. Resident of Sai Spring Apartments, even in MC also, resident of Sai Spring Apartments, F108 302A, third floor, second cross, first stage, BEL layout, Bharat Nagar, Bangalore. Same address.
No, the Bagalkot district.
No, please show him this.
Yes.
Please compare this with your criminal, this miscellaneous application order. It's one and the same. Tomorrow? Tomorrow. Pass or not pass? Yes, next. Yes.
number 9.
Yes.
Is what?
Yes. How much is the amount granted?
6,000.
What is your income?
61,000 is the salary of the husband here. I'm appearing on just twice here.
Notice.
Is number 20. Is forward. Dev Shetty.
respondent. I filed an annual letter. The Honorable Court has permitted the respondent to withdraw the amount. So it will be directed to issue the name of the first register, first respondent. She is the mother. So it is very difficult to withdraw the amount because she does not have joint accounts. This is the reason. She is the mother. She is leaving her.
No, amount is deposited. You are also a party. You are representing the children. You are representing the children. Mother is representing the children. She is a party. So why she cannot withdraw?
But the office has informed me that you have to give rights deed. That is the reason.
They have given a joint deed.
Deed in the name of two. One is minor, another one is attendant of the second respondent. The joint account they have to open, but that is the reason. If it is issued in the name of first person, they can return and see taking care of it from the 12 years.
You can't have any objection for that.
Consultation. The matter is referred to mediation.
No, that is one aspect. As far as the withdrawal of the amount is concerned, if the mother is permitted to withdraw, you cannot have any difficulty.
I know objection, but what suggestion? Not the matter is referred to mediation. There is a order of restitution against the husband.
Order of?
Restitution. That was passed in 2016. Before the mediation, she is not ready to come and write. Because her brother, who is a police, he is behind her.
No, the maintenance
That's
is...
what pending.
No. Maintenance,
Tomorrow it is posted abroad.
maintenance is not granted to the wife.
Both,
No, it is for the children.
wife and son.
Then now is she entitled when you are not ready to join the husband when the restitution is already passed?
So, madam, there is, I even have challenged that order before this honorable court.
What happened?
There is no stay.
No stay.
Since 6 years it is pending. Even notice is not ordered and it is no stay.
One condition, see, even in this petition, even the single word they have mentioned, even the main maintenance order has been challenged before this honorable court. That was confirmed with this honorable court. Even the honorable high court confirmed that what has stated by the trial court that the conjugal rights have no effect in recovering the maintenance. It is clearly mentioned by the order in the institution, order of the institution. That was confirmed by this honorable court. Even they have not said a single word about what they have challenged the main order.
It is submitted that by the respondent that this court has already permitted the respondents to withdraw the money, withdraw the maintenance that is deposited by the petitioner. We submitted that as there is no account in the name of the children, it has become difficult for the mother and it's not permitted to withdraw. The registry is directed to the respondent mother is permitted to withdraw the amount that is deposited on behalf of the child also. This is the and the DD may be the fresh DD may be given in the name of the mother. Yes.
Mediation. Interim order.
Interim order earlier granted is extended. List matter on when?
Tomorrow.
That's why list matter on 13th of January. 12th of January. 12th is Sunday. You want to come on that day? 15th. 15th.
Not because some functions are there in my house.
When do you want that?
Before I reach 9,
8th of January. Yes, then. Next. Yes.
Admission matter, seal number 21, answer. Seal number 22. Srinivas Vinayak, yes party.
What has happened?
This matter, previous occasion, your lordship suggested them what would be the quantum of arrears. Since arrears was not denied, and from the maintenance was awarded from the date of the order. Therefore, 10,000 was awarded. 10,000 is being awarded. Lordship directed them to propose what would be the quantifying the arrears. I have inquired with the party from my end. 7,000 would be
7,000 for the period which where the case is pending.
Yes.
where you are not granted. From the date of petition till 10,000, according to you it is 7,000.
But the party to deny because this matter memorial.
This is matter on, the matter tomorrow. Yes. At the request of land council, the respondent. Yes, please. Yes.
Seal number 22. Should be Saurabh Desai.
Contracted with the party in the chamber and suggested the wife to join her husband. As on today, he is ready, and also your lordship, as per the instruction of this honorable court, 2 times along with the council on record, since council on record is a family friend of the husband, they visited the wife house. They invited her to join. She refused to go, and now her condition is again her parents along with the husband has to join, come and take her. In fact, your lordship, in the last occasion, previous bench has suggested she wanted to purchase some gold for the festival. Even he has given 1 lakh rupees. As on today, maintenance is not denied. It's been 14 years, he has not filed any divorce petition. 14 years they are separated.
What's the difficulty now?
Please.
What is the
A
problem?
difficulty, she says that he should make a house in a Hubli and he should live along with her. Since his posting is in Gangavati and he is working as circle inspector, your lordship. This is a sensitive area. In fact, sometimes he does not even get the leave. Now she demanding that he should come and live with her in Hubli itself.
What is the amount that is granted with the family court?
There is 20,000. She herself is deserted from the husband. Now he is ready to take her. In fact, today also your lordship in trial court.
How can he come to wherever you stay? You want him to come?
No, my lord, this is not the
On
fact.
this, that I remember that. You say she is ready, but
She
he
is
is
ready.
not.
He has not made any
Two times,
cause.
your lordship, 2 times he has visited her house in the last 15 days, 20 days. Now again she wants.
No, she is ready now.
If she is ready today itself, he is ready to take her.
On 22nd Sunday, she is ready to go with him. And she will, as per the earlier order,
again,
she will be taking
No,
along
no,
with her.
I'll record all that.
Please.
And if this submission before the court and if she raises up any other issue again, then no, that will
There
have
is
an
no
impact.
issue at all. There is no issue at all between the.
No,
on
on
the
that day, if I remember,
respondent side.
no, one
On
minute.
25/9/2024, there was an order by this honorable court. And they have to actually take her, coming to her house, take her, and she was ready, and it was stated that she will go to his house along with her some accomplice because of the gap between the husband and wife for a long period. And that was also suggested, and that was all made the arrangement. But at that time,
Why is it
the
22nd?
husband has not made a single
No,
call.
what is that 22nd so auspicious?
Please.
22nd, is it an auspicious?
No, not that. Only Sunday, she will be ready to go along with because she has to make some arrangement. If he comes, that is her only condition is that
No,
husband has
every
to
time-
come and take
no,
her.
no, every time
Because
this
he
problem-
has not made any.
No.
Please.
Every time this problem is happening about coming and taking.
Please.
We'll say that instead of 22nd, let her come to court on 20th. He'll come here and they'll take, court will record that.
And the submission is that the matter to be kept pending.
It will be kept
Kept
pending.
pending and both the parties will have to file
What
affidavit.
we'll do is, let her come on Friday to the court. From here, he'll take her.
Please.
And we'll list this matter somewhere in February. That
Please.
day you can submit before the court what has transpired.
Please.
Yesterday, we had been example for a section case. Today, this is personal case. ASP and IG are not doing one more view on 20th. What I'll do is make sure arrangement for a vehicle so that he can come to my place. Because that myself had been to the house of the wife. Myself was there. Because I know very well from the beginning. So I had been to their house and we had a cup of tea and asked her to come. So she was ready. She told some particular dates. I don't know why she did not come. So I asked him. Morning also he told me that the IG had also told him because we did not inform. We informed to the
Let him come on Friday to the court. From here she'll go.
20th.
Yes, Friday.
Please.
This is matter on Friday. Let him make an intermodal granted is extended. Let him make arrangements for her to take from here. Yes. Yes, sir.
Seal number 24. Ganesh Vaibhati. 24.
Yesterday also they were not here. Yesterday also they were not here. Issue notice on the main petition as well as an IA first process. Oh, the respondents are served, no, all are served. Please argue. What has happened? What did the court dismiss? That's the only thing. Only that you're only on that point. No, it's checked from the date of petition.
My lords, there has been a mistake from my senior friend. Our case is at 20 serial number. He got confused.
Oh.
He is confused.
Yes.
Serial number 24. Ganesh Vaibhati.
No representation for the petitioners. Left this matter on February 18th. Yes, next.
Serial number 25.
The suit for partition is separate position. But the petitioner is a bank, which the suit properties were given as security for a loan that was obtained in the mortgage. Pursuant thereto, since he was a chronic defaulter, but the proceedings under Synthesis Act was issued under the grace defend number 1. Let's after 13/4 notice was issued. He approaches this honorable court by filing a petition, since it had come at the stage of option. He obtained the interim order, conditional interim order saying that he shows bona fides by depositing the sum of 1 crore. He did not comply the interim order. However, interim order was granted subject to payment. Since the auction date was over, he withdraws the petition. He gets a suit filed by his son, contending that the suit properties are similar to the
Joint family
and he is having a share in the property. What he challenges there is an order passed by Section 14 of the Synthesis Act. To be declared that it is not binding.
You filed a petition under Order 7 rule.
I filed an application under 7 rule 11. That is rejected by the court saying that the jurisdiction of the civil court is not offset.
Senior is on his legs.
You have an interim order in this?
No, that's the reason why yesterday's matter is taken.
Yes. Will grant an interim order.
Okay.
Huh?
Kindly give us some time.
It was only to enable me to elect for the interim order.
Tomorrow will. If they don't turn up, tomorrow will come. No, at the request of the counsel for the respondent, this is matter tomorrow.
Serial number 26. Serial number 27.
My lord, I appear for petitioner, my lord. I pray for an adjournment.
Who appears for the respondent?
It's Mr. Prashant Matpati. I have informed them.
Yes, after vacation at the request on 4th of February.
Obliged.
Yes, next.
Serial number 28. We are Andy.
It's okay. Yes.
In this case, the sentence is
No, they are only on the point about from the date of petition.
Yes,
You are questioning the quantum.
Please,
How much is granted?
20,000 is granted.
What is your income?
60,000 is there. But I have a
How much? 60.
60,000.
Uh,
I have a younger mother with health issues, and I have a younger brother also who is.
No, that's why considering all of them, 20,000 is a reasonable amount.
My lords, my client is ready to accept her back without any conditions. Or he
Is she ready? She is not ready.
Or he is ready for even for one-time settlement also. He got it.
No, one-time settlement.
I'll make that.
Please find out if she is ready for one-time settlement, we'll pass an order. Shall I post it on Friday?
My lords, after vacation.
After vacation?
Please. My lords,
You submitted that the husband is ready for a one-time settlement. Then counsel. Then counsel for the petitioner submits that. He'll get the specific instructions and also come up with a figure which is ready towards one-time settlement. List this matter on 8th January.
Please, my lords, I forgot recalling those.
What is it?
Yesterday, my lords, I was permitted to compile the office objective during the course of.
What is it? What happened? What is this order?
Yes, my lords, I have accordingly, I have compiled.
No. What is this? When is it dismissed?
On 10th, my lords.
Because conditional order is passed.
Please.
This court on 21/11/2024 had passed an order granting a week's time to comply with the office objections and also observe that the office objections are not complied within the time. The petition should stand dismissed without further reference to the court. It is submitted that due to some communication gap, they couldn't comply on the day, and as such, the petition stand dismissed. He submits that thereafter they have come up with an IA seeking to recall the order dated 21/11/2024, and this court has also permitted them to comply with the objections. Objection pending consideration of the IA, and now it is stated that now they have complied with the objections. Accordingly, IA number
3 of 2002.
3 of 2024 is allowed by recalling with the order dated so and so, and the petition is restored to file.
Obliged talks.
Yes.
Serial number 29. Even for
No representation. After vacation, list on 10th of February.
Serial number 30.
Petitioner.
Yes.
First petition for by
Seeking enhancement.
Only enhancement or in the alternative one of the maintenance is granted from the date of order.
You want it to be date of petition.
Petition. Yes, sir. One.
What is the amount granted?
Amount granted is 38,000.
What is
35,000.
What is the salary of the husband?
60,000.
60,000.
Yes, as per may I make one submission? 35,000, 15,000 to wife, 10,000 to the children who are studying in 7th standard and 9th standard. May I make one submission saying that all of them could be calculated as 10,000 each, so that it can be disposed of. And the one from the date of petition. The submission, as on this day, I am regularly paying the amount of 22,000 as per the order of this honorable court.
22,000.
And earlier, prior to order passed by this honorable court, I was regularly paying an amount of 20,000 to my wife and children towards their welfare. So now he is trying to and he has got to hold a parent.
No, it is like this. There are 3 people this side.
Yes.
And even if he has to take care of the parents, no, it could be like 30,000 for both of them is fine.
No, since they are old age, now they are under the medical treatment.
No, because they are because there are 2 children. I can understand. If it is
already fixed by this honorable court, can you confirm? I am regularly paid, and I have put the responsibility of.
We'll make it 25. We'll make it 25.
Please.
The agreed with the order dated 15th May 2024, whereby the court has granted 15,000 maintenance to the wife and 10,000 each to both the children. Both the mother as well as both the wife and husband are before this court. The application filed by the wife is RPFC number 100125 of 2024, and the husband's petition is RPFC number 100099 of 2024. The wife had, on behalf of wife, had filed the petition seeking maintenance of an amount of rupees 1 lakh, an amount of rupees 1 lakh for maintenance and for litigation expenses, It is a case that she has no source of income. The husband is a software engineer and is getting monthly income of rupees 3 lakhs and also owns used properties at Bangalore, Hubli and Kalgatti, and is also having an apartment at Bangalore, getting rents around 60,000 per month. And apart from that, is having agricultural lands and failed to maintain the wife. It is a case of the husband that the wife herself has deserted the company of the husband and she is not entitled for any maintenance. The court, considering the respective cases of both the parties, has come to the conclusion that the wife is staying away from the husband on a reasonable cost. And when it comes to the income, the court has considered the exhibit P19 to P23 and also the exhibit P19 to 23A, that is the RTC extracts in respect of plot number 267, 268, 287, 288 situated at Kusikal and plot number 77 situated at Rainal Taluk, Hubli, which shows that the husband is having landed properties. And also he is paying installment of an amount of rupees 1,80,463. And considering the salary of the petitioner, the court had granted an amount of rupees 15,000 to the wife and 10,000 each to the children. Next paragraph. When counsel appearing for the wife submits that the wife has to take care of herself and the two children and she has no source of income. When the husband is having, when there is evidence on record to show the financial capacity of the husband, the court ought to have granted a reasonable maintenance. Further, the court had granted the maintenance only from the date of order. It ought to have been from the date of petition. Next paragraph. When counsel appearing for the respondent for husband submits that as per the earlier he was paying 20,000 as maintenance and as per the order of this court he is paying 22,000
per month.
He is paying 22,000 per month. It is submitted that he has to take care of his old age parents who are suffering with health ailments. He submits that if the interim order is, shall I record that? That your submission that it can be confirmed. It is submitted that the interim order that is granted by this court at 22,000 may be confirmed. Next paragraph. Having heard the counsels on either side, there is a material on record. There is no dispute about the income of the husband at 60,000 and also there are other properties he's owning which is part of the record. It is his case that he has to take care of the parents as well. The wife has to take care of herself and her two children. The husband is ready to pay an amount of rupees 22,000. Considering all the facts, this court is of the view that 25,000 would be an appropriate amount. But this court has also observed that the amount that is granted is from the date of petition or from the date of order. It should have been from the date of petition. In that view of the matter, this court is passing the following order. The order dated so-and-so is passed by so-and-so is modified and the amount of maintenance that is granted is reduced from 35,000 to 25,000 and the amount is from the date of petition. Accordingly, both the RPFs are disposed of.
And liberty is only granted to withdraw the amount deposited by me for this amount.
The respondents, the respondents are at
No,
liberty.
you have to transfer it to the trial court.
The registry is directed to transfer the amount in deposit to the trial court, and the respondents are at liberty to withdraw the same. The wife is at liberty to withdraw the same. Yes. Yes.
Number 31, Santosh certificate. Santosh Pirao.
I'm asking for respondent manner.
Where is the petitioner?
Santosh certificate.
After vacation? No representation from the petitioner. Counsel for the respondent is present. This is matter on 6th of January.
6.
Yes, thanks.
Number 32, Ashikar Gurji.
Correspondent.
The petition is filed by the son-in-law. The first respondent, mother-in-law, that she filed a petition before the principal.
You are the son, mother has filed.
Yes.
How much is grant?
15,000 is the amount not awarded by the court. But the main contention is that the mother-in-law is filed this petition at the instance of second respondent, that is the other son-in-law.
She has not claimed from the other son.
She has claimed not lesser amount from this. Since not.
So now how much is given?
15,000 means so far as I am concerned.
Other one is?
10,000.
So you want it to be equal? Then we'll say 10,000 from him also.
Kindly go through and take also.
No, why the court has taken like this?
The court has considered I am working as a police constable.
Your income is how much?
My income, the take home is 45,000. And I was working in army, and I'm getting a pension from the also. It is 25,000. So I have other liabilities.
So apart from 45, you have another 25.
Yes.
So 45 and 25 is 70.
Yes.
So
I have other liabilities like my child's education loan and
only child?
one daughter. So there are other liabilities also.
And what about the other son? What is his income?
What has happened to the mother? He has filed the petition against his own son. And as far as concerned for the respondent number 2, both of them are staying together in one house, my lords. And subsequently, my lords, he is kindly go to page number 10, my lords.
No. She filed, you are appearing for the mother.
Yes, ma'am.
So mother files a petition against two sons for maintenance.
Yes, ma'am.
And she is staying with one mother, one
Yes,
son.
yes.
What is that?
But he from respondent number 2, my lords, second children, she is getting 10,000, my lords. And
why is she asking maintenance from him and staying with him?
But sometimes even he will throw out from the house, my lords. Now, my lords, she is staying in her daughter's house, my lords. And even my age is 73, my lords. At this age, my lords, where I have to go, my lords.
Well, anyhow, 25,000 for one lady is more than enough.
And that in a village.
In a village, we'll make it 10,000. Please come.
May I request you? 10,000 is also on the higher side. I owe the duty, my lord, to maintain my mother. That is one aspect. But apart from that, Lord, since Lord, he is working in a police department. The medical claim is also available to the petitioner. He is looking after the mother. He is providing the medical treatment and other things. Through the
Pay 10,000. That's not a big amount. Agreed with orders passed in criminal miscellaneous number 82 of 2023, dated 5th of November 2024. One of the son, that is first respondent in the criminal, your first or second? First respondent in the criminal miscellaneous has filed this petition before this court. The mother had filed the petition against both the children, claiming maintenance of an amount of 40,000. What is this? What she will do with all this money?
No, at the instance of this
40,000 from the respondent number 1 and 10,000 per month from respondent number 2. It is a case that the children are not taking care of her, and as she is aged about 73 years, she is not in a position to take care of herself. The court, considering the fact that the petitioner herein, who is the first respondent therein, was police constable, and also is having receiving pension as he was an ex-serviceman. The court granted 15,000. The court has directed this petitioner to pay 15,000. Other son to pay 10,000. Agreed thereby. One son is before this court as a first respondent. Let counsel appearing for the petitioner oblique first respondent submits that this is a collusive petition filed by the mother. It is stated that she is staying along with the other son, and along with the other son, it is stated that as he is working as a constable, the medical reimbursement is also available to the wife mother, and he has been taking care of it. The amount, and apart from paying the maintenance to the mother, he has several other obligations where he has to take care of the family and the two children. He submits that the amount that is granted by the court is on the higher side. Next paragraph. Then counsel appearing for the respondent mother submits that both the children are not taking care of the mother, and in fact she is staying along with the daughters. The submission of the counsel for the petitioner that in collusion with the other son, this petition is filed is not correct. It is stated that the court, considering all the aspects, has rightly granted the maintenance and no grounds are made of seeking interference with the well-considered order passed by this court. Next paragraph. Passed by the court. Next paragraph. Having got the counsels on either side, peruse the material on record. This court has the court had granted 15,000 maintenance from this respondent, from this petitioner, and from the respondent. Another is served.
Yes, sir.
Is served.
No, it is not so.
The notice is ordered to him.
No. This
Not
is
at
coming
all.
for the first time.
The respondent, second respondent, is directed to pay 10,000. Before this, after his submission, the second, no, leave it last.
Even before the court below also, my lord, you were served and paid in person.
Considering the fact that the petitioner is earning an amount of 70,000 per month, and already an amount of 20,000 is directed to be paid by other son. In the considered opinion of this court, the amount of maintenance can be reduced from 15,000 to 10,000. Next paragraph. This court is not proposing to issue notice to the second respondent, as no adverse orders are passed against him. Next paragraph. Accordingly, this court is passing the following order. The amount of maintenance of 15,000 that is granted by the court by order dated so and so is modified, and the same is reduced to 10,000 accordingly. Petition is partly allowed. Yes, next.
Seal number 30.
Yes.
It's as well as petition.
How much is granted? How much is granted as maintenance?
30,000. For respondent number 1 it is 10,000, and for respondent number 2 is 20,000. Respondent
No,
number
1 minute. Respondent number 1 is who?
she is the wife.
5, 10,000.
10,000.
And
Respondent number 2 is the son, 20,000.
what is your income?
I'm unemployed. I have been terminated.
You didn't contest before the court?
I have produced all the documents.
Let's see. What was
page number 40 man?
Page number?
40 minutes. Para 26 minutes.
Page number 40. Please read.
It is repeated say of this week and the learned counsel for respondent that the respondent underwent medical treatment for his depression caused on account of alleged
No, not about that. About your income, there is a discussion.
No whisper is made about my income. Only on the basis of social status, which my brother has having that Lordship has come in the para 26 of the judgment. I read the last.
How much you will pay now?
That's interim maintenance. I have paid for 6,000.
Pay 10,000. The counsel for the petitioner submits that the court had granted 30,000 as maintenance, and without there being any evidence to show that the petition is earning and is capable of paying the amount of 30,000, considering the submission of the land counsel to the petitioner and the fact that both the wife and the child has to maintain themselves, they shall be stay of all further proceedings on the condition that the petition shall continue to pay an amount of rupees 10,000 by 5th of every succeeding month, and the arrears at 10,000 shall be paid within 8 weeks. Same, either of the orders are not complied with, conditions, state stands vacated. Registry is directed to issue notice to the respondents. Yes, next. Yes.
Seal number 34. Mrs. Niranjan.
Final memo.
What memo?
Both the parties are sufficiently good.
Take that.
And in the criminal miscellaneous of family court police, they filed a joint memo stating that they are written. He is the respondent now. And he is ready to withdraw the MC petition which is filed by him before the Bangalore family.
No, nothing we will, I cannot record anything on this memo. A memo is filed stating that the dispute is settled, accordingly dismissed. A memo is filed stating that the disputes between the parties are amicably settled. As such, nothing survives for consultation in this petition, accordingly dismissed, and the memo is taken on record. Yes, next.
Doing the hearing. Seal number 25. J. Murali.
Appearing in the petitioner is a husband, your lordship. There are 4 respondents claiming maintenance from the husband, your lordship.
How much?
30,000 has been ordered, your lordship. For the wife, it has been denied on the ground that she is also working, your lordship.
You are appearing for whom?
Husband, your lordship.
How much? What is your income?
Your lordship, I'm receiving about 80,000 in hand, your lordship.
80,000.
80,000 in hand, your lordship. Now, what has happened is he has suffered a lot of medical issues, your lordship. There is enough material to show that he is undergoing medical treatment. He is not saying that he is not willing to take care of the children, your lordship. The quantum of the maintenance award is on a higher side. That can be seen, your lordship.
For 2 people or 3 people?
3 people is 30,000.
3 people 30,000 and you have 50,000, and still you feel that it is on the higher
There
side.
are deductions and my medical treatment is also going on.
How much your take home salary?
Take home is around 84,000 or something.
84,000 your take home.
Yes, sir.
Then you can't pay 30,000.
In fact, your lordship, the age of the children is just 4 years and 6 years, your lordship. Now
They'll go to school.
They are going to the school, your lordship. That is not in dispute, your lordship. The amount is on a higher side, your lordship. Maybe in the near future, your lordship, the expenses go on with the children. The husband is willing to comply, your lordship. Right now, he is not in a position to comply 30,000 of quantum of maintenance awarded to him.
There should be a reason why he is not able to comply.
The reason is that, your lordship, there are
What is there on paper? Show it on paper.
on there from the husband side, your lordship, there has been no records put up in the joint court.
What have you filed anything before this court?
I'll file it, your lordship.
This is matter of revocation.
Your
And the
lordship,
request of land counsel the petitioner.
your lordship, may I request tomorrow only, your lordship. The reason is the quantum of arrears is going up to 17 lakh, your lordship. Now we have already paid 9 lakh, your lordship. As on today, I have already paid 9 lakh. If date is given tomorrow, your lordship, I'll file the documents before this honorable court. And it
How does it matter? Why tomorrow?
because they are proceeding with the execution procedure.
So 23 matter.
Yes, sir. There
There is no stay till now. There is proceed.
There was a delay, your lordship. This honorable court was pleased to condone the delay, your lordship, day before yesterday. So
No, the amount, and even as of now, the court feels that 30,000 is a reasonable amount.
the husband is willing to pay 20,000, your lordship. It's not disputed. He's also willing to pay 20,000.
First of all, then I'll post this matter on Friday.
Yes.
By that time, at 20,000, the arrears you deposit,
Yes, sir. I'll ask the.
then we will grant stay.
Yes, sir. Now,
This is matter on Friday.
including the arrears.
At 20,000,
Yes, sir.
right from the date of petition till now, whatever are the arrears,
Yes.
whatever that you have paid, deducting that,
Yes.
if any amount is, if you are ready to deposit, come with the deed, we grant a stay on the day.
Must be, sir.
Yes.
Seal number 36.
I'm attending for respondent. I know last week on
Then
the.
council submits the council, the respondent submits recently they have filed a This is matter on 3rd of February. Interboard is there?
Yes, sir.
Interboard earlier granted is extended till then. Yes, next 37.
Seal number 37. Commission decide.
Notes approved by the order of recall of PW1 and PW2. Respondent has got raised before this one.
Which year is the MC?
The MC is of the year 2021.
When was the evidence of PW1 and 2 is concluded?
PW1 and 2 is concluded on 30th.
30th of?
30th July. PW1 30th July. May I take through this page number 100?
Before going to that, then when was the recall application filed?
Recall application has been filed immediately. The very next day. Recall application has been filed, and immediately that is the recall application has been filed, but again PW2 was examined on the very next day, and on that day also time was sought because of the absence of the counsel. Counsel on record was called. He was abroad.
Let's see the impugn order.
The impugn order. Para number 6, I can see.
Page number.
Page number 110. The observations made are totally additions. That is what page number
Let's
6.
read from para number 6.
It is noticed that from the records that the present petition is filed by the petitioner against the respondent on 14/12/2021.
Petitioner is who, wife or husband?
Petition is by wife.
Against the husband.
Husband has sought for restitution. For dissolution of marriage, solemnized with the respondent. That the present case, the petitioner filed her affidavit in lieu of examination in chief as PW1 on 15/6/2022, and thereafter matter was adjourned on several dates for hearing dates of hearing for further chief of PW1. Chief examination of PW1 is closed on 13/1/2023, and thereafter matter was posted for cross-examination of PW1 on 24/1/23. Then on 14/2/23 and on 28/2/23 and 17/3/23, but the respondent not cross-examined the PW1. May I take how it is incorrect and erroneous observation? May I take the order sheet I have?
1 minute.
All incorrect observations are made.
Both you and you're for the wife, you're for the husband. Both the husband and respondent are just like that casually taking adjournments before the court.
Because the respondent has sought for restitution, and even before the conciliation also, it has come on record. The wife has agreed for conciliation, but at the behest of someone third party, she has again resigned. It has come in the ordership. The respondent didn't want to offend by producing these documents. 29 documents are there, which are WhatsApp chats, all records, everything. All these documents, they show that entirely incorrect statements have been made in the petition. And he didn't want to offend her feelings in the public. So she wanted to...
Please come. Agreed for the order passed in I number 11 to 13, whereby the husband has sought for recall of PW1 and 2 for further examination, is rejected. Land counsel submits that the findings that are given by the court or contrary to the record, and there was no intention on the part of the husband to drag on the matter. And if the application is not allowed, it would cause a lot of prejudice to the petitioner. Considering the same, they shall display of all further proceedings on in MC number 327 of 2021 till the next date of hearing. Next part, then counsel to the petitioner shall take out notice and summons on the counsel affected respondent before the trial court and shall file a memo to that effect by 7th of January. If the memo is not filed, the petition shall stand dismissed, the stay granted by this court shall stand vacated without further reference to the court. List this matter on 8th of January. Yes, next.
Issue number 38. Will you put them?
The petitioner for this honorable court is right. The respondent is
You are appearing.
The respondent was appearing. I do not have any objections to allow the instant petition.
What is the petition?
My submission. Plus the 13B petition was filed by the petitioner and the respondent for the mutual consent. Divorce. That came to be plus in the number 8 of the petition itself as page number 11. I'm sorry, it is in number 9. Plus it was specifically clarified that on 4/10/2018, son is born, and the respondent, the petitioner before this honorable court will the wife have taken all the responsibility of the son. That is specifically mentioned at paragraph 8, page number 11. Even in the affidavit filed by both petitioner as well as the respondent, there is an averment to that effect that the wife has taken all the responsibility of the son. Because that allows us to get at page number 24 and page number 27. So far as affidavits are concerned. The petition was allowed, mutually the consent divorce was granted. Subsequently, because insofar as the child responsibility of the child is concerned, there was no single aversion to the entire judgment. Therefore, we sought for clarification and addition of that provision by filing an application to section 152 of CPC. That application is at page number 29 HFE. That came to be rejected. Saying that
No, technically speaking, you people wanted a compromise decree to be passed. What you wanted, the court has granted.
In the petition itself, we had sought for clarification that the child responsibility had taken the
It is there in the petition.
Please, page number 11.
It is not reflected in the order.
Orders. That is what we sought for.
Then what did the court do now?
Court says it is addition, it is not permissible under section 152. In fact, covered by the judgment of law.
Not necessary for that judgment.
No prejudice is caused to any parties.
Where is it now? What is the court read and understand?
Please, not the page number. Order the operative portion, one also get it at page number 39.
Page number?
39. 39. Para 5.
Please come. The present petition is filed, agreed with the orders passed and an application under section 152 of CPC, whereby the court has held that, has rejected the application. The facts of the case are, both the parties had filed a petition under section 13B, and the same was or allowed, and by judgment and decree dated 3/12/2021. Now, the present application came to be filed stating that for the proposed amendment correction in the judgment, as it is their case that the child by name Viraj is in the judgment it is observed that the child by name Viraj is in the custody of the petitioner number 2, and petitioner number 2 has taken full responsibility for the care and maintenance of the child. I think we'll have it tomorrow. Let you file the wakalat today.
It's very lot, if the lots permit. Wakalat usually and the affidavit is also very
I think we'll do it tomorrow. It doesn't, it's not right, because of final order. File it today. Land counsel so-and-so submits that he has instructions to file wakalat on behalf of the respondents. The list this matter tomorrow.
Please, along with affidavit, Lord.
Along with the, and he has instructions, and he's also filing an affidavit.
Please.
Along with the district is directed to list this matter, along with the affidavit.
Please.
One request. Tomorrow there is some function in my house, so I may not be able to.
Not necessary.
Please.
Yes.
Keep your prayer.
Yes, next 39.
Number 39. Here part.
Hmm.
Non-persecution.
Huh?
Non-persecution in the criminal business.
Before the court.
Public court. Yes, the address is the same, earlier, the respondent filed.
Will order notice. Will order notice.
Yes, the take notice to, the respondent in the MFA case, same membership, the Dharwad, Dharwad take notice.
Let counsel for the petition is permitted to take out notice on the counsel appearing for the file in the MFA number so and so, pending before this court. List this matter on 9th of January. Yes, next 40.
Still number 40.
What is that?
Challenge to the interim maintenance is on the two grounds.
You are for the husband.
Yeah, I'm for that.
How much is granted?
15,000 is granted. My salary is 70,000.
17. 70.
Yes. But she issued me the notice before filing the petition under 125. Reply notice not wherein I categorically said that to come back we will leave the matrimonial house. Thereafter, she files a 125 petition. In the that was sent for conciliation. Conciliation report where I said that I am ready to take a start, leave the matrimony. But she refused. And she wants the interim maintenance and pursue
She has, court might have given a reasoning. What is the reasonable cause for her not to join you? You can't compel her to join you.
Compelling is one aspect. Your lordship kindly see, there has to be willful negligence or desertion on my part.
It's not willful negligence, sir. The wife staying away from the husband without a reasonable cause.
Yes.
Then she is not entitled.
Yes.
She might have shown what is a reasonable.
No,
She, according to her, there is harassment from you.
No,
and you can't compel her to stay with you.
No, I am not compelling. But the thing is, para 4 may kindly see, page 92.
Anyhow, we will consider it once the other side comes.
Only 15,000, what
You have 70,000.
No, but
As of, at this point of time, let it continue.
at least introspection. It may be 10,000.
Just because you have come to the court. No, for granting something, there should be some reason. It looks 70,000 is salary, court grants 15,000.
Even otherwise, I have raised loan that has come in.
Notice.
It
It is not appropriate. Notice to the respondents. Petitioner is permitted to take out hand summons on the counsel appearing for the respondent before the trial court. This is matter on 6th of January. Yes.
Still number 50. 41.
On the last occasion, as per the direction of the Supreme Court, they have submitted a report stating that my shop is situated not within the operation.
Why is it adjourned on the day?
But since the report was submitted and I have received it on the particular day, so I did not go to the report. Which was
You are not having the file that day.
Yes. And as per their own report,
So your petition has to be allowed.
yes.
The interest of public.
That's what that day we have discussed on that, if I'm right.
I have
Now,
narrated.
rule 5 or rule 4?
4.5.
Rule 4.5 says about the vicinity, and if it is, that I think that's what I've asked you. Is it like if it is within the prohibited, then the deputy commissioner has a power, irrespective of anything? Is a power conferred with the DC? That's what is the question.
Yes, sir.
What is your answer to that?
No, it is coming under the prohibited area.
Not coming. That's what your submission is.
100 meter is there, madam.
That's a prohibited.
That's correct. But in the interest of public, the deputy commissioner
That
has
is
passed.
what I wanted you to tell me on the legal aspect, on the provision, looking at the provision. Is there any provision which says, though it is not in a prohibited distance from any of those
No,
structures.
no, that-
In spite of that, the DC can do something on a public interest.
No, the public has given representations and agitations
No, no,
they have made.
they will do,
Based
but
on that only.
he is bound by the act. Please come to the act.
Yes. Are fine. Are five
Closure of shops on certain occasions.
Please.
4A. Then you're saying, you're talking about restriction in respect of location of shops.
Please. 5 for me. Five subclass 4.
Huh.
The deputy commissioner may by order, after giving the licensee an opportunity of being heard, direct such license to seek the location of any shop, with a view to secure the convenience, morality, tranquility, decency, or safety of the public in the interest of
That
public.
is in compliance of the provisions.
Please.
That is in compliance with the other provisions of the act, where it says that it should be within so and so.
Regarding this, my submission is that only in the interest of public, the persons, agitation, and the schools are very nearly situated. 150 meters, the government school is there. 150 meters. They are giving the complaints to the Tahsildar and DC, saying that the bottles are falling in the ground. Every day they are facing this problem. And the public is also passing through the temples.
In fact, the court wants to pass an order as submitted by you, but the court wants from, that's the reason why I'm again and again asking you.
It is in 2016 itself, it was rejected and directed him to sit the shop in 2016 itself. For that, they have approached the appellate authority. Appellate authority is directed them to file a
Mr.
representation.
Counsel,
They
you
have not.
understood what is the query of the court? And you have to answer to that.
For the last 22 years, I am doing the shop over the same premise.
Not about that. No, you may be. No, according to, there is no dispute about the fact that your shop is beyond 100 meters.
Almost all the
No, 100, no, no, 100
beyond
meters. No, 100 meters.
Yes.
Now, according to them, though it is beyond 100 meters, because of your shop situated there, which is very near to the so-and-so education institutions and all, your shop is creating trouble. No, understand what is the court's query first. In that case, though it is within 100 kilometers, 100 meters, whether the DC is competent to pass an order under 5 or not.
So, yes, so if it is coming within the purview of that is 100 meters, then deputy commissioner has every right to pass an order. If somebody who are strangers, who are not the neighbors.
The distance between 100 meters and 150, there is no much difference.
No, but they are away from like 250, 350 and other things. Lordship may kindly turn to the objection, that is report which is submitted by the very deputy commissioner, where it states they are far away from my place. And moreover, some persons, that is who are unwanted in the society, they are making allegations. School authorities are not making allegations. Temple people, that is, trust committee are not making allegations. And my shop is not a shop.
They are
Only
saying
it is
that
outside.
they have given the complaint to
It is
the
outside where persons buy and go away from that my shop.
where is the bottles are sold in the ground.
They are not allowed to sit in my premises. It is the outlet where they will purchase and go away from my shop.
And
For the
surplus
last
fine
22
kindly
years, no one, that is the persons who are leading, the persons who are having even restriction of, they are never objected for money.
Please tell the court whether such a power is conferred on the deputy.
Please.
Whether such a power is conferred on the deputy commissioner or not.
Subclass 5 will reflect this. Subclass 5. The excise commissioner may at his discretion. Subclass 5. That excise commissioner may at his discretion and for the reasons to be recorded in writing exempt from the application of these rules in the case of distributor license referred to in clause 11, rule 3, the Karnataka excise sale of.
What is that clause 11 of rule 3?
Please.
That is unconnected with this.
Not unconnected. Because he has a distinctive power.
For clause 11 is certain acts not permitted.
As on the date when license was granted to me, I have received no objections from all the neighboring persons. At that point of time, making verification only, the authorities have issued a
No, the
license
court has some doubt on this.
Please.
No, as far as that 100 meters, no, it is clear. Your case is clear.
Please.
Now, in spite of that, whether the deputy commissioner has no power. to do when something is brought to his notice.
No, if the running of a shop is detrimental to the interest and security of the people, then he has every power. Deputy Commissioner is the authority who can pass. But no such untold happenings, that these incidents have taken place in that premises.
Basing on what you are saying, no, they say that they have complaints from so and so.
No,
Who are they? Who are they?
They have not produced that report.
Where is
They
that?
have to produce, actually.
No, how will he know the reports?
No, I have produced along with my statement of objection.
Look at it.
I have filed.
Look at it.
I have filed. Along with my statement of earlier it was filed. Earlier it
No,
was
he
filed.
said he has produced it. Show it to him.
Website API. Only, not only that person. Tahsildar, to the Tahsildar, the school committee has given.
Look at it. This is matter. Day after tomorrow.
Day after tomorrow, there is some inconvenience for me.
Tomorrow. Tomorrow.
May submit only one letter which is issued from Karnataka Rakshana Vedike. They are no way concerned to my premises.
Karnataka?
Rakshana Vedike. They are
Means? What is
they are
that?
bound to protect the interest of that is Kannada language in our Karnataka state. They are no way concerned to my property.
Are they near to your property?
No, absolutely not. They are from a different place.
School authority has given to the complaint to the Tahsildar. That copy.
No,
School authority.
no such
Look
letter.
at it. Look
Yes.
at it.
Yes.
Tomorrow.
Please.
Next. At the request of Councillor Krishna. Next 42.
Number 40.
Interior model.
The board all granted is extended. Next 42.
Number 42. You can fill in the time.
Yes.
As your lordship has already heard for this thanks to your lordship. Still single rupee has been not paid. Still a single rupee has been not paid by the
That is
respondent. Your lordship.
totally incorrect. Let's kindly see the minutes prayer. That they are challenging the order dated March 7/6/2022. They have filed an application under section 24 of the Hindu Marriage Act, seeking interim maintenance. Trial court has passed an order directing respondent to pay 10,000 rupees. I am paying regularly.
Where is the?
Moreover, on the last act of the occasion, the lordship directed me to minutes. File a minutes.
When she's saying that you have not paid, what is the material to show you have paid?
Last occasion, legacy.
Then why are you saying?
Your lordship,
This is
last
one.
time they already shown that
Minutes.
they are paying regularly the school fees of the child, your lordship. They are not paying any relating to the maintenance.
Let her file minutes recovery proceedings.
10,000 days, including the the educational expenses or excluding the educational expenses.
Excluding the.
Then in that case, he has to pay 10,000 per month. And with all the school expenses, how much it is coming for a year?
And
60 your lordship.
Huh?
60 your lordship, because day by day increasing the price in the
That you
market. your
forget
lordship.
about it, that you forget. No, we are on the point. According to you, he is not paid. According to him, he is paying the fees. No, for example, 10,000 per month is granted. It would come to how much? 1,20,000 per annum. He is paying how much per year to towards the education of the child. He has faced memo. Have you looked at it?
Indeed, your lordship, he has only showed the documents that he paying the school fees, your lordship. But the
School fees who will pay? Is there any order for him to pay? And then he is paying. So after paying the school fees, how much? What else has to pay? And that 1,20,000.
your lordship, at least 15,000, your lordship, in order to take care of herself and the minor.
You are not understanding the question. I cannot help you. This is matter after vacation. This is on 15th of January. Yes, next.
Number 40. Looking at repeat via journal.
Successfully, the order of interim maintenance was, we have referred this petition. It has been directed to pay 30,000 maintenance. Kindly peruse Annexure G, page number 32, 37.
Any interim order in this?
No, madam.
Huh?
No interim order. Subsection.
No interim order. This is matter after vacation.
This after vacation.
Interim order.
Interim order is not there from 23. Yes, next. Yes. Next.
Seal number 44. Then seal number
46.
45.
Petitioner is, this is finally, this is heard for some time. This is a matrimonial matter wherein Rajni sources, Rajesh was not adhered. Interim maintenance, wherein I was not allowed to file my assets and liability affidavit, wherein I have contrasted with that respondent is working. She has sworn to a false affidavit saying that she is not employed. I have summoned the particular.
When was the criminal miscellaneous filed? Which year?
2022.
When was the order passed?
It is order page number 22, madams.
Dated.
2024.
How much time you want for filing assistance statement of assets and liabilities? Court will wait for you that when you will file the statement.
Lord, on account of respondent's mistake, I was constrained to knock the doors of family court, filing matrimonial case, seeking divorcement. As a counter blast, they filed this criminal misdemeanor seeking maintenance. Both were clubbed, and at that particular time, when they were seeking maintenance, I was opposing that by necessary I was opposing put forth in my necessary efforts whatever the case I was I was putting my defense in. In that particular time, I got to know that she is working, and I requested this honorable court to summon those service efforts so that she's my opposition is she is working. So
this court has to record a call for the.
No, the family.
Then what happened?
In the meanwhile, interim maintenance order was passed.
Have you filed your statement of assets and liabilities before the court?
No, no. Sorry, Manoj, regarding trial court, I don't have any information.
Both the parties should file place before this court. The statement of.
Sorry, Manoj, we are supposed to file wakalat, Manoj.
Kindly
post it after vacation, Manoj.
In these premises, two adjournments were taken. Today morning also, attempt was made to seek adjournment. Only issue in this matter.
2 times, Manoj. 25th November.
Why? How many times you want?
No, Manoj.
2 times is not sufficient.
Sorry, Manoj, the client has not yet sent.
Seeks time to file wakalat. This is on 25/11/2024.
And next one.
5/11/2024, and now again today. Then which year is this? Will stay the order then.
It is already statement.
Then what is the urgency for you?
It is stayed, Manoj.
Only point is involved in this matter, Manoj.
Please, Mr. Counsel, please understand. Everything can't happen like that. Interim order earlier granted is extended till the next date of hearing. This is matter. And then, what is the urgency for you? Why are you insisting as if like something is going to happen?
No,
This is matter on 10th of February. By the time both the parties shall file the respective statement of assets and liabilities. Yes, next.
No, this is already filed. Court below.
What do you want now? Tell me.
Nothing. As it is heard by this honorable court, I was pressing that.
But they're asking, I have to accommodate them, is it not? If you are in their place, I would.
Please.
Yes.
Sorry.
Number 47.
Yes.
And I have submitted my
We'll hear these matters after vacation, not now. All these final hearing matters.
My lord, they have matter at the settled. They are ready to fight with petition number 1. And my lord, some arrangement is made to petition number 2. My lord, because the doctor is